Hello and welcome to another edition of The Front Page on GNAT TV. My name is Andrew McKeever. I'm the managing editor of the Manchester Journal, and I'll be your host today. And today it's our pleasure to have with us here in the studio Patricia Nelson, an attorney from Bonneville, Vermont, who's a specialist in the licensing of intellectual property and will be talking to us about copyrights, patents, and intellectual property in general. She counsels clients in the areas of domestic and international trademarks, privacy, and advertising issues. And she's here to talk to us today about all those things. She'll be giving a seminar here at GNAT TV on January 28th at 6 o'clock for those of you who may want to come and really hear more about the subject in depth. Patricia, welcome to GNAT.
Thank you very much. It's great to be here.
Great to have you with us, and thanks for making the time. This is kind of an interesting subject for a lot of folks, particularly in the worlds of art and commerce, I think especially, but I think it probably has applicability to a wide range of endeavors. But just to kind of get us started, tell us a little bit, or explain in a little more depth than I'm able to do, what exactly are we talking about when we use the terms intellectual property or copyright, patents, or trademarks? They're not interchangeable terms by any means, as I understand it.
No, they're not. Intellectual property is kind of an overall rubric of works that are created from the mind, as opposed to real property. And each falling under that rubric are copyrights, which protect original works of authorship, expression. Trademarks tend to protect brands. I mean, people think of trademarks with a brand, and the whole purpose behind the trademark scheme is to let consumers know the source of a particular good or service. And patents primarily protect inventions.
Okay. Well, now, intellectual property then, I guess one of the things that I suppose a lot of people trip over when we talk about intellectual property is when does one person's idea, original idea, or work of art, when it's used and manipulated in another way, when does that original protection go away, and when is someone able to take that original idea and use it for something else or a different purpose?
Well, as I said, copyright protects original expression. It does not protect facts. So when we're talking about copyright, there are certain exclusive rights that a creator obtains when they create a copyrighted work. You basically, when you have a copyright to something, you have the exclusive right to reproduce the work, to create derivative works, to perform and display the work publicly, and to distribute the work. So those are the kind of the exclusive rights that are given to a copyright owner. It doesn't take much to create an original work of authorship. All you have to do, and the Supreme Court has actually talked about this in a case that's known as the Feist case, and you have to have a spark of originality. So that's basically all you need to create a copyrighted work, and it has to be fixed in a tangible medium of expression, which means that basically it has to be recorded, it has to be written down, it has to be videotaped. It can't be sort of a transitory moment. So that's what a copyrighted work is. Okay. As I said, facts are not copyrightable. So the copyright, the purpose behind copyright law is to kind of allow people to benefit from their creations. Right. So when we're talking about derivative works, a derivative work might be, so if you write a novel and then somebody wants to create a film of that novel, that would be a derivative work of the novel, and the copyright owner has the right to create that. There are certain limitations on a copyright owner's exclusive rights, because the whole purpose behind the copyright scheme was to allow the dissemination of knowledge. And it was embodied in the Constitution. This was something that the founders thought very important enough to actually put in the Constitution, and it's in Article 2, Section 8 of the Constitution, where copyright owners and inventors are given exclusive rights to their work. And the purpose was to give them a limited monopoly to allow them to benefit from the distribution of their works, but also to allow the creation of work, to encourage and incentivize people to create, so that they would do so and that this kind of knowledge would disseminate throughout the country. Okay. So there are certain limitations on an exclusive right. So to go to your question, a copyright owner has the right to do all of those exclusive rights, but the public also has certain rights to use a work. So if a copyright owner has created a work, there has to be that spark of originality, so it can't just be kind of a useful object. So somebody can copy something that, you know, has no sort of element, like a phone book. If you, you know, put together a phone book and it's just an alphabetical listing, you don't really have any copyrightability. Somebody else can just come along and copy that. Right. There are situations where, and this is something that gets into a huge issue for many people who are trying to create works of art, whether they're trying to create documentaries or, I know this is a big issue for people at GNAT, it's like, when can you go and take a work without getting permission from the copyright holder? Right. There's something called fair use, and this is sort of a limitation on the exclusive right of the copyright owner, which allows somebody to make use, and that's generally for purposes of education or news reporting, things like that. You're allowed to make certain limited uses of a copyrighted work in that situation.
Well, then let me ask you a question then, which comes up an awful lot in our field, in journalism. A lot of times, especially when we're under deadline pressure or in a rush to kind of get a story out or something done, I'll find myself in a situation where I'd like, for instance, to get a picture of something, to go with a story to illustrate something, and I can go to, you know, Google Images or I can go on the web and I can find a picture of somebody who's done something. How do I know that I can just copy and paste that picture off the web and use it in the paper or on my own website?
Right. Well, this is one of the big issues that's come up in the digital world. Now that works can be disseminated so easily, so much more easily than they ever could before with digital transmission. It used to be to copy something, you basically had to sit at a printer. If you wanted to copy a novel, you'd have to sit at a printer or you'd have to write it out before technology was available. Much to a lot of people's either dismay or lack of understanding, it's just because it's out on the web does not mean you can just take it.
It's just there for free.
Right, it's not there for free. As a lot of people are actually finding out. And there's been a lot of lawsuits that have been developing over the years with the advent of digital transmissions that have come up. It's a big question. It's a fact-based analysis. As I said, there was something called fair use. And it's a really interesting area. As I've said to people before, you could do, you could talk about fair use for hours upon hours. We're not going to do that today. But generally speaking, if something is out on the web and you're using it for purposes of news reporting or reviewing a book, for instance, right, and you want to use an excerpt of a book for review purposes, generally the idea behind the copyright scheme allows for that. Okay. There are 4 factors that courts use to determine whether something is fair use or not. They look at the nature of the use, what the character and purpose of the use is. Is it for news reporting? Is it for educational purposes? Is it for scholarship, research? They look at the nature of the copyrighted work. Is it a highly creative work? Is it an original work of art, or is it just kind of a form that somebody came up with? They look at the amount that you're using relative to the whole work. Are you using just a small bit of the work, or are you using the entire work? And they look at the effect on the market for the copyrighted work.
It strikes me that it would be very easy, though, to accidentally trip over one of these legal boundaries. I mean, you don't mean to, infringe on someone's copyright or borrow somebody else's work inappropriately. You know, you just need it, and it's out there.
Right.
Seemingly in the public domain, you know, and not only that, but they want you to use it because it would help spread the word of whatever they've been doing. But you really need to take a deep breath first, I guess, if you're in that position, even if you're kind of under the gun time-wise, especially.
Right, absolutely. And, you know, I mean, that's a little bit of, I think, of a myth when people say, well, I'm giving publicity to the copyrighted work. Well, you know, this is a way people earn their living. So you have to kind of respect that. And especially, you know, for somebody like you, you create copyrighted works as well. You're writing
it works
things.
the same way.
Right, so it's a little bit of the golden
Yeah.
rule. It's like, would I feel comfortable with somebody taking, you know, my work without payment or, you know, sharing in the revenue to me? And it's not only, you know, I've worked with both, you know, content owners and creators and, you know, artists, and, you know, a lot of times people feel very personal to their work. So it's not only a matter of money, it's a matter of control and how a work is being used. I mean, some people might feel like, you know, I don't want my work associated with something that they're doing. So there is certain amount of respect that has to be, you know, thought about when you're just taking works. And, you know, this comes up a lot with music. People think that they can just use music and it's on the web and there's file sharing going on. And this was a big issue with the whole advent of digital file sharing with music. And people didn't think twice about just, you know, well, you know, I used to lend records to my friends. You know, people still know what those are. But, you know, so what's the difference if I'm just, you know, sharing a digital file, or a digital download of a song? But basically what was happening is with the digital sharing of songs is the whole market for CDs and records was being undercut. And so, so the industry was actually decimated in a way. And by the way, they took a very aggressive stance about going after people for doing this. And, you know, the record industry, the recording industry of America was very aggressive in filing lawsuits and shutting down a lot of these services. I don't know if people still remember Napster and Grokster. And so those were basically shut down by the recording industry.
Hence the arrival of iTunes and the attempt, I guess, to kind of regularize that.
Exactly. So a whole new industry came out of trying to find ways to do this legally.
Well, you remind me of something that happened to me 2 or 3 years ago, which pointed out the intricacies of all of this. In my other life, my wife and I own a little shop in the area, and I got the bright idea to shoot some videos of the interior of the shop because we never felt that we could get the, you know, kind of the feeling of what was inside the store in either a still photo or in any of our advertising. So I come along one day and with my little video camera and I shoot all these videos of the inside of our shop, and background music, which we typically have playing, is being picked up on the video. I wasn't even thinking about it, beyond the fact that, oh yeah, I should probably put some background music on it just to kind of liven the video up. So, you know, I shoot my video, I upload it to YouTube. I think I'm being really cool and modern, and, you know, aren't I really ahead of the curve here? And about 3 or so months later, I got this polite email from the owner of the copyright of the music that had been playing in the background, which was completely incidental to what I thought I was doing, which was showing products that were on display, saying, gee, Mr. McKeever, you know, we're happy that you use our music in your store, but you can't have it as part of a YouTube video. And it really surprised me, and I guess I found myself thinking, wow, you can really stumble across this threshold very easily.
Right.
I mean, does that sort of thing happen a lot where people just sort of, without thinking about it, just sort of trample on somebody else's copyright?
It does happen quite frequently, especially now with what's happening with, as I said, digital distribution of content. You know, and music is an interesting case because, first of all, it's a little complicated. When you're talking about music, you're talking about two different copyrights in the kind of scenario you're speaking of. There's a copyright in the song, the composition itself, so the underlying lyrics and composition, and then there's a copyright in the sound recording. So you're actually, if you're trying to license music, you're actually talking about two different copyrights. one in the sound recording, one in the underlying composition, and they're held generally by different owners.
Wow.
So that can get complicated, but it's, when you're talking about YouTube, I mean, there's all these people who are posting videos of themselves doing cover songs, and doing, posting their videos with music up there, or clips of various films or things like that. And there's actually been a lot of lawsuits against YouTube for this. And actually, YouTube has a sort of a licensing scheme with a lot of content owners that allow them to post clips from films and television shows and things like that, where they've arranged licensing agreements with sort of film studios and different things to a blanket, what we call a blanket license, which allows them to show some of these things up there. But there's also some of the laws that evolved in sort of the digital age. I mean, basically what was happening is things were happening so fast on the internet that laws had to kind of catch up with what was going on. And there's something called the Digital Millennium Copyright Act that came about, which sort of allowed for what we call a safe harbor in sort of the legal terminology for internet service providers like a YouTube or Google, things like that. Which allows them to kind of escape liability for user-generated content. Okay. So there's a whole sort of legal scheme of what they have to follow. So they have to post a notice on their terms and conditions, which of course nobody reads.
Right, that's
right, exactly.
gigantic long thing that you just click
People
accept.
should read those. I mean, everybody just
will.
clicks on them, but there's a lot of information in there about what you're allowing and agreeing to. But there's notices that are posted in those terms and conditions, which basically says, if you are a copyright owner and you see something posted on my website and you think your copyright is being violated, send me a notice and I'll take it down. And there's specific information that you have to provide, and take it down. And if I take it down and respond, then I'm not liable for copyright infringement. But you can still go after the person who posted it.
Well, how would one find that out? I mean, if let's say you're an artist, you've created a painting or a picture or a photograph of some sort or another, and you use it for whatever the immediate purpose was. I mean, how is one supposed to find out that somebody on the other side of the world or the other side of the country or whatever, is taking that and using it for something else, using your work without paying you for it?
Sometimes it's just, luck. There are, when we're talking about sort of larger companies, film studios, music, industry, they have people that are basically looking into this and scouring, looking for infringement. But if you're just a random individual, sometimes it's hard.
It's up to you to kind of monitor it, I guess.
So yes, sometimes
control
it's
the
just
web
luck. Right, exactly. Yeah. And, you never know what's going to happen. There was a recent case that came up that dealt with a photographer who had taken some images. He was a photographer. He went to Jamaica, I believe, and took photographs of Rastafarians and Rastas. And he published a book about them. And the book apparently didn't sell very well. It was a small selling, and I think the book was out of print. But somehow an artist named Richard Prince, who's a fairly well-known artist, saw images of these Rastas and started to incorporate them in some of his collages. He creates collages and paintings, and had them at a fairly large, the Gagosian Gallery. It's a very well-known gallery in New York, and the artist found out that his images were being used in these collages. So it was sort of a random thing. I don't know how Richard Prince found the book. As I said, it was a small printing. The book was out of print, but somehow he found these images, started using them in these works of art. The photographer sued Richard Prince and the gallery for copyright infringement, and actually won in the district court in New York. The district court determined that this was copyright infringement. And then they appealed, the artist appealed, and it went up to the second district in New York, the appellate court in New York, who actually reversed the lower court's decision and determined that this was not copyright infringement, that because the use was transformative, and this goes to some of the things we were talking about earlier about that whole nature of disseminating and being able to use copyrighted works for the creation of new works and dissemination of knowledge. This was considered, because this was a new work of art and the artist had transformed the original work into something new and highly creative, this was not
So it was
copyright
no longer
infringement.
photographs, but was now a picture,
Right,
so that
exactly.
made it transformative.
Exactly. And this
Okay.
is a whole area. It's a very kind of fun.
That sounds like a really murky gray area.
It is, and as I said, it's a very fact-based analysis that courts use, going back to those 4 factors that I discussed earlier. But it's actually, you know, for copyright lawyers, I mean, it's kind of a fun area because the cases get to be so kind of interesting. And again, it all goes to this notion of, you know, checks and balances in the copyright system of protecting the author, but also allowing
stimulate innovation.
Exactly,
to,
exactly.
To take an idea and do something more with it that benefits society in some way.
Exactly. So some of the things that have been, you know, considered fair use, especially if it comes to a situation where the copyright owner wouldn't necessarily license the work, and this goes back to what I was talking about earlier about control. So areas of like parody and satire, and a lot of times the court will be very lenient in those types of situations because, again, it goes to kind of a speech issue too, and there's a tension between copyright and free speech. So there's always an area where if, for instance, the copyright owner would be trying to prevent use of their work to prevent speech, that the courts will allow use of that work.
Do these, when conflicts come up where one artist or someone perceives that their work is being inappropriately used, do they typically go immediately to like a litigative situation or a lawsuit, or is it usually the first step is to try and work out something outside of a court, or is there any kind of typical pathway for that sort of thing to be resolved?
Yeah, I mean, I think generally speaking, most people try to work things out without going to court just because it can be very expensive. So, you know, the first step would be if somebody saw somebody using their work, they might say, you know, stop using it, or I want compensation.
Right.
Then if for some reason that doesn't look like that's going to happen, then they can go the legal take a legal course. And there's, you know, you can get injunctive relief, which means you can actually go to court and have the court ask the person or do an order to have the work stop being disseminated. And there's also the potential for statutory damages and attorney's fees in certain situations with copyright infringement.
What about social media? How does that play into it? I mean, is that the same as like basically the web in general, but you know, with the advent of Facebook and Twitter and all the other social media platforms that we now have available, is that also playing a role in kind of making copyright protection more complicated than it already was?
Well, in a way, yes, it does. Again, it goes to the sort of the dissemination, the ease of dissemination, but also there's all this user-generated content up there now. So everybody's a copyright creator. So when everybody's posting their photos on Facebook and they're, you know, doing their videos of them playing guitar or whatever, those are all owned by the individual who's creating those works. But, you know, and this goes to, again, to one of the things I was saying in those terms and conditions, anytime you post something on a Facebook or a Twitter, if you read those terms and conditions, what they're saying is that you are giving those companies a sort of a blanket license to do whatever they want with those copyrighted works. So if you post a photo of yourself on Twitter or on Facebook, for instance, if you read the fine print in those terms and conditions, you're basically giving Facebook the right to publish that, to distribute it, to copy it, to license it to somebody else.
You're giving it away.
You still own the copyright technically, but they have an exclusive or a non-exclusive right to do whatever they want with it.
If you shoot a photo of yourself that's just so absolutely brilliant that someone in California who works at Facebook decides, oh wow, this is exactly what we want to use to help publicize our new service of some
Right.
sort,
you're basically giving them the right to do that.
Okay.
So
Interesting.
you can still use it yourself, but
Yeah,
and it's
right.
Obviously royalty free, so
Right.
they don't have to pay you for that.
Oh my God.
So so there's a lot of information in those terms of use that discuss this.
This sounds like a situation that primarily affects artists or people who are creating, works of art of some sort or another. But I imagine it also applies to folks who are in commerce and in the IT field in
Sure.
particular. Some bright guy invented a smartphone, and now we see evolutions of them, and I imagine there must be a lot of monitoring of what goes on as smartphones and other high-tech gadgetry evolve. So it's not just an issue that affects artists.
No, absolutely not. Software is generally protected by copyright, and that's a huge industry. It's a huge issue. Every time you use a software, you'll see the license agreement. So you're basically, you may purchase software, whether it's Microsoft Word or, any other, Final Cut Pro or the kinds of things that people are using.
Yeah.
Digitally, those are all governed by license agreements. You are licensing those works. You don't own them. So it's a very big issue, and it actually is a huge issue internationally, especially with sort of copying, wholesale infringement of software. I mean, you hear about this going on in various parts of the world. There's a huge government interest in protecting this because it's an industry, whether it's in China, whether it's in India, whether there's countries that are known for sort of disseminating copied software or films. So it's a very one of the biggest exports that the United States has is intellectual property.
Right.
Whether it's film, whether it's software, those are primarily the biggest industry. Music.
So your copyright
television.
protection that you file and register for here in the United States, that's good worldwide, or would you have to file for copyright protection in whatever country you might feel you might need to, like China or wherever else?
Generally, the international copyright is based on reciprocity. So there's sort of a worldwide copyright scheme.
Okay.
So most countries have copyright protection, and it's kind of a universal. There's been an attempt throughout the world to kind of make it uniform. So generally speaking, and I'll say generally, copyright, at least on the books, I would say. That's the important distinction as well. On the books, generally copyright, in the United States, it's original work of authorship. The copyright term is life of the author plus 70 years. That's generally a worldwide thing.
Convention. Okay.
But the level of protections in various countries differ.
It varies.
Yes, quite a bit.
Well, that's only a small piece, I think, of the areas that you're going to be covering in the seminar that you'll be giving here at the studios at GNET come January 28th at 6 o'clock. Certainly, there are a lot of folks out, I think, in our listening area that probably would be interested to know some of the finer points of what you can and can't do when it comes to copyright, and particularly in the era of the internet, I would imagine.
Well, as I said, it does affect quite a bit of people, whether they're writing books, whether they're creating videos, whether they're doing documentaries, filmmakers. So this is an area that, it's a minefield with everything that's out there, everything that's available, the way that you can combine various works. People want to use music.
Yeah.
People are creating videos. They want it, like you did in your store. You want to, use various, whether it's music, whether it's photographs. So it's a very difficult situation for people trying to figure out what's going on, what they can use. It's a big issue for documentary filmmakers. This is an area that's caused quite a bit of trouble for a lot of people because of the costs that can be involved in licensing copyrighted works, especially in for filmmakers who are trying to create documentaries because they want to, if they want to use film clips from earlier eras, they want to use photographs, they want to use music. The other thing that comes up, I mean, here is an example. There was a documentary film, you probably know, Eyes on the Prize.
Oh, yeah.
That was a famous, very fabulous documentary created about the civil rights movement. And it came out in film, I forget when it did originally come out, but once it came time to do the DVD, when the filmmakers had gone out and licensed, rights to film clips from news articles or news reporting or photographs or things like that. They had licensed it for the film itself. But once a DVD came out, all of a sudden this was a whole new media, and the licenses did not apply.
Okay, right.
So they had to go back and relicense everything for use and distribution in a DVD. And this is what comes up with new technologies. So it was actually not on the market for a really long time because the cost involved in doing that was almost prohibitive.
Sure.
And also going back and getting every one of those licenses again.
Tedious.
And this is what's happened in copyright as the development of new technologies has come along. You may have licensed something years ago, but the license didn't necessarily cover the new technology. So all of a sudden your license isn't valid anymore. And this was one of the big issues that came up as new technologies and digital technology was developed was, what do those licenses cover? And that's an issue for everybody who's working in this area. It's like when you may be doing the right thing and going out and getting a license, but you have to make sure that the license is going to cover all of the uses that you're anticipating.
It's all in the fine print. Well, we're going to have to leave it at that for now, Patricia, but I wanted to say thank you again for coming in. Patricia Nelson is an attorney who specializes in copyright law and intellectual property. She'll be giving a seminar here at GNAT TV on January 28th at 6 o'clock, and those of you who might want to know a little bit more about that rather complicated and evolving subject, it sounds like, might want to get in touch with the station here. You can go online to gnat.org or call the station at 802-362-7070 and get more information. Well, Patricia, thanks again for stopping by. Thank you all for watching, and we'll see you next time.